This report is essentially a catalog of the 400 plus changes the administration has made to immigration during their time in office. We started to keep this list internally at the beginning of the administration because they were making changes at such a rapid fire pace, and some of them were very small and very technical. And this list inside MPI ended up being a really helpful resource. So we decided to publish it and to put it out there so it can be a resource for everyone else. And one of the benefits of having all of these changes, kind of tightly packed into the pages of this report is it helps you see some of the trends with this administration's agenda on immigration. For example, many of the changes reflect the administration's really strong knowledge of immigration law and regulations and their willingness to enforce things that have been on the books for years but never been implemented. One example of this is they've put into force a 1996 law that has allowed ICE to begin levying fees of up to $799 per day for unauthorized immigrants who remain in the country in violation of a removal order. So it seems like a really small and technical changes, but when you take these all together, it has added up to a really monumental change and evolution of our immigration system. One example of a technical change they made that has actually has potential to be alone make very big changes to the system is public charge. This has gotten a lot of news, so you may have heard of it, but it's a restriction that's been on the books since the very beginnings of our immigration system, but really rarely implemented. In public charge restricts individuals from coming into the United States if the government determines that that individual is likely to be reliant on public benefits when they get to the country. And the Trump administration has really expanded the definition of who would fall under this restriction. Its implementation has been rocky due to legal setbacks, but once implemented and really enforced, it could significantly change the flows into the United States, disfavoring women, the elderly, and nationals in Central America and Mexico. So overall, looking at this report, the really broad changes that have been implemented by the administration would include closing off humanitarian benefits, sealing the southern border, making life in the interior really uncomfortable for immigrants, both legal and unauthorized immigrants inside the United States, and reducing legal immigration into the country. And the pandemic has only accelerated the changes that this administration has made. I'd say there are 3 changes that have really been kind of the biggest that this administration has made during the pandemic. The first is a CDC order. The second would be the April 22nd presidential proclamation restricting immigration, permanent immigration into the country, and then the June 22nd proclamation restricting temporary workers. So I'll talk for the rest of my time about each of those and the implications for those. So the CDC order is another great example of this administration diving into the laws on the books and finding things that have never been enforced before, but can be used to really restrict immigration into the country. There was a 1944 law that allows the Surgeon General to restrict the entry of individuals deemed a public health threat. So the administration used that law to and issued an order coming from the CDC director that restricts the entry of individuals that are not authorized to enter the country. The effect of that has been essentially ending asylum at the southern border, and that's actually something the administration has been working on for years. We have many, many policies that have come down over the prior 3 years that really restrict asylum at the southern border with the goal of really just having no one enter there. But in one movement with the CDC order, they've really accomplished that goal. As a result of this order, asylum seekers, the vast majority of them, are being expelled from the southern border. We don't know a lot, unfortunately, about the procedures under which they're being expelled, and there are a few who are still being let into the country to in theory apply for asylum, and we don't know a lot about who's chosen and why, unfortunately. But in all, that CDC order has really completely dismantled asylum at the southern border. So the second big change that I referenced was the April 22nd proclamation. This proclamation is interesting because the president issued it not justifying this major immigration change with the public health crisis, but rather with the economic crisis, saying that he is restricting permanent immigration into the country in order to protect U.S. nationals on the job market and in the economy. What that April 22nd proclamation does is end immigration into the country in several categories, many family-based categories, including, for example, parents of U.S. citizens, siblings of U.S. citizens, spouses and children of legal permanent residents. But it also restricts the entry of anyone applying from outside of the country for the diversity visa lottery. And the effect of that proclamation actually accomplishes something that the administration previously tried to push Congress to do, which was they tried to get Congress several times to end the diversity visa lottery and to significantly reduce family-based migration, which they have labeled chain migration. So in one move, under the opening given to them by the pandemic, they've accomplished something on immigration that previously all of us would have thought they would need congressional cooperation to do. Then last, there's that June 22nd proclamation, which significantly, which restricts temporary workers coming into the country in major non-immigrant categories. The H-1B visa is the most common visa for skilled workers coming into the country. That has been restricted. They've also restricted J's, L's, and H-2Bs, which are a little more niche, but still major categories for temporary workers coming into the United States. Now, anyone applying for those to come into the United States on those categories, if they're applying from outside of the country, they're restricted from doing so. And this, again, like the other provisions, accomplishes something the administration was already working towards prior to the pandemic. They had significantly increased scrutiny of applications of temporary workers, especially the H-1B visa. And now with this one movement, they've significantly reduced that flow. And then I'd be remiss if I didn't mention the fact that we still have travel bans in place for foreign nationals traveling from 31 countries. And as with many of these procedures, it's kind of hard to see an end in sight, not only because the pandemic is still raging in the United States, it's still a very present problem, but also because these provisions accomplish things on immigration that the administration was working towards for a long time, for years before. It's hard to imagine them walking these back willingly, even once the pandemic is no longer a prevalent issue. We don't have transparency from the administration on how exactly they're implementing the CDC order at the southern border. We do have leaked instruction to CBP officers that show no consideration for people who are interested in applying for asylum. Instead, if migrants who are apprehended in between ports of entry or who approach ports of entry without authorization to enter the country, if they proactively say that they have a fear of torture in their home country, not a fear of persecution, just a fear of torture, then they may have a chance of applying for humanitarian benefits in the United States. We know that there are a few people that are still being permitted to apply for asylum, but we don't know why. We don't know who these few people are, or why the administration is not applying the CDC order to them. These can't be walked back by a future administration, and nearly every change under President Trump has been issued by executive fiat, right? It's been an administrative change. It hasn't gone through Congress, which does make it simpler for a future, more immigrant-friendly administration to reverse them. But the reality is that they were done at a very rapid-fire pace, and no Democratic administration would have the time or resources or political willingness to spend this much time on immigration, undoing each of these changes. Not only is it just a reality that we have a lot of other priorities center front for the US government, but also Democrats have not been very active or interested in acting on immigration. They have been very quick to say that they want to undo what President Trump has done, but they haven't really put forward a vision for what that immigration system should look like. So I think that there's just a lack of willingness there to undo each of these changes. And then also, a lot of them shouldn't be quickly undone. For example, all of the changes at the southern border, the president really has accomplished a great reduction in the number of unauthorized arrivals at the southern border. If you quickly undid those, you probably would see surging arrivals at the southern border. And the system we had in place before President Trump took office, it was a very, very imperfect system. So ideally, you'd want an administration that not only was willing to invest in undoing Trump's actions, but also who would be thoughtful about it, and implements ideally a better system on the other side. And I don't know, considering all else that's going on in the United States right now with the pandemic, the economic crisis, the public health crisis, the problems with health insurance, the national conversation on racial injustice, it's hard for me to picture a future administration really investing this much in immigration.
The president had initially took office on a claim that he was going to stop largely the unauthorized entrance of immigrants or the undocumented population. But very shortly after taking office, he actually attacked specifically legal immigration. And he did so to the business community through his order called Buy American, Hire American policy. That came out in April 2017, just a few months after taking office. What that's resulted in my experience as a business immigration practitioner, is several changes. And as Sarah was describing, this is why it's so difficult to undo what the administration has done, because these changes have come out through various kinds of policy memorandum that you cannot just rewrite overnight. This is included, for example, just making it harder for companies to sponsor foreign workers by increasing the numbers of requests for evidence for documents and long boilerplate templated requests. This has gone up 3 times the amount that by prior administrations. By suspending something called premium processing that allows employers to quickly be able to make an offer to a potential employee and then process their immigration paperwork within a matter of a couple of weeks. But with multiple suspensions of premium processing, those have taken months, and it's become difficult for the movement of labor, which is critical to the success of business and our economy. From removing the deference in prior approvals, meaning where a company had somebody that they have sponsored in the past and then wanted to seek an extension of their work visa, those cases are now reviewed anew, and all of the prior documentation that they have previously provided is now ignored, to requiring interviews for employment-based green card holders, green card applicants, under the guise of protecting our national security. Having gone to numerous of those interviews, I have yet to see how national security is even raised in a single one of those interviews, and it has become actually creating a backlog in overall immigration handling. So now coming back to where we are, if you look at these previous actions as whittling away at the business immigration process, the proclamations post-COVID-19 are essentially a sledgehammer to business immigration. Those 2 orders, the April 22nd and the 24th, I'll focus on the June 24th order rather, which implicated H-1B workers who are specialty occupation workers, seasonal workers under the H-2A program, J-1 exchange visitors, and the L1 executives, managers, and specialized knowledge workers of multinational corporations. Okay, so how did the president do this? I think that's one question we've got to ask ourselves. How was the president able to do this? He did so under Section 212F of the Immigration and Nationality Act, which permits the president to bar immigrants if he finds, and this is important, if he finds that it is in our national interest. So that implicit in that section that gives the president these powers is the notion that the president has to make a finding. And in the past, our courts have been hands off of the president's powers because they're usually rooted in national security interests as opposed to a domestic economic policy. And that's what he's done here. He's testing these waters where he's claiming, I've got the right to bar immigrants because it's in our national interest, because it's against our it harms our economy. And I think that this is significant because study after study by economists have shown that immigrants do not harm our economy and in fact grow our economy and have multiple spillover impacts into the local economy. So I think it's critical here that we don't fall into this trap in believing that the president can do anything by proclamation just because he claims this notion of a national interest. And in fact, what I like to go into those economics really quickly, if I may. First, the math itself doesn't add up. Okay, so the president argued, as well as his surrogates have stated, that over 525,000 U.S. jobs would be protected by the actions he has taken. They've maybe blocked about 167,000 people because all of these bars relate to people who are outside of the United States, not in the United States, and there's just not that many people that would have been impacted by the bar. So there's not 525,000 jobs that are being protected. These studies that show that immigrants indeed help grow our economy. First off, there's innovation. Okay, foreign workers in STEM fields are critical to the innovation in the growth of patents. This is acknowledged by the Department of Homeland Security itself. Okay, so the administration, the Department of Homeland Security acknowledged in its own reports when it wanted to seek extensions of OPTs that foreign workers help stimulate innovation. This was also argued by the Cato Institute in their study recently in May 2020. And as recently as the Department of Homeland Security's move to increase immigration filing fees. They specifically state, and I'll quote it here, we recognize that immigrants and international students make significant contributions to the U.S. technology industry. That was just 2 weeks ago. Then there's entrepreneurship, okay? Immigrants are twice as likely to start businesses than U.S. born natives. And so that is important. That's critical to our recovery. And third, there's the job multiplier effect. And a study by the American Enterprise Institute for Public Policy Research gave a good example. For every 100 H-1B workers, it results in an additional 183 jobs for U.S. natives. For every 100 H-2B workers, it results in an additional 464 jobs for U.S. natives. The overall ripple effect is there's actually job creation, and our economy does better with the immigrants. In particular, the high-skilled workers in H-1B programs tend to be part of that job creation process. There has been high unemployment rates since COVID-19. But the reality is that it has not been in the STEM fields. So in January, we were unprecedented low rates of unemployment in the STEM fields of 3%. Just after the pandemic, and as early as in studies from May of this year, those rates are at 2.5%. because these are the critical workers. They're the workers, frankly, they're the workers that are allowing us to have the Zoom call right now, right? They're the ones that we need to allow us to get back on our feet and be able to work remotely and provide the technologies that we all need.
The Trump administration's Department of Homeland Security issued a new memo on July 28th following a decision by the U.S. Supreme Court in June, finding that the administration's 2017 rescission of DACA was arbitrary and capricious. The court's decision restores DACA to its original implementation in 2012. The new DHS memorandum, while saying that it is an interim decision while the administration figures out what to do with the DACA program, drastically alters DACA. This latest move has added to the uncertainty immigrant youth have experienced under this administration. I'll be sharing guidance for DACA recipients and guidance for those who wanted to request DACA for the first time. The July 28th DHS memo directs USCIS to reject any initial DACA requests, meaning from people who have never had DACA before. Individuals who applied for DACA for the first time in light of the Supreme Court decision should expect to receive notice that their initial request has been rejected and will have their application and associated fees returned to them by mail. The July 28th memo directs USCIS to reject advance parole applications from DACA recipients and return them along with their filing fee to the applicant unless USCIS determines the applicant demonstrates exceptional circumstances. It is not clear what USCIS will consider to be an exceptional circumstance. The memo also clarifies that any already approved advance parole issuances will remain valid. If you're interested in advance parole, we recommend you speak to an attorney or a DOJ accredited representative before applying and before you travel outside of the United States, even if you have been granted advance parole. USCIS will continue accepting and processing DACA renewal requests. Those who are eligible for renewal should still consider submitting the request, especially if they have less than 150 days before their current DACA expires. We recommend that individuals consider renewing their DACA, consult an attorney or a DOJ accredited representative who can provide an individualized assessment, including whether they are eligible for another more permanent form of immigration relief. Based on the DHS memo, if your DACA renewal request is approved, your DACA and employment authorization will be valid for 1 year rather than 2. If your DACA and employment authorization have already been approved for 2 years, your DACA and work authorization will remain valid for 2 years, but the next time you apply for DACA, if approved, your new DACA and employment authorization will be for 1 year, not 2. The per application fee remains the same, $495, but this move effectively doubles the cost for DACA recipients and places the burden on DACA recipients to renew every year. This is of great concern because the ability to pay DACA-related fees has long been an obstacle for many DACA recipients, and at a time when many are facing unprecedented financial hardship, this additional yearly fee could hinder eligible individuals from applying, putting at risk their employment authorization and protection from deportation. This abrupt change in the middle of a health and economic crisis to a program that has been in existence for 8 years warrants further the need for Congress to automatically extend DACA and work authorization, and to do the same for temporary protected status holders, which is another community whose lives have been upended by the Trump administration's attacks. We'll continue monitoring DACA renewal processing because we are concerned that USCIS's budget problems, as well as the recent changes to USCIS's policy manual, may cause delays in processing. On July 15th, USCIS released an updated USCIS policy manual, creating additional steps for USCIS officers to take. People applying for immigration relief like DACA, TPS, and for work authorization must now show that a favorable exercise of discretion is warranted, in addition to showing that they meet all other eligibility requirements for the specific immigration relief they're applying for. USCIS officers must now evaluate a list of discretionary factors to determine if the person warrants the immigration relief and/or work authorization. For example, what they've done since arrival, ties to the US, and any health issues. We are concerned that this will lead to arbitrary immigration relief denials and even longer adjudication processing wait times for certain immigration relief and work authorization requests, since officers now have to do this extra analysis and document it. All of these things add up to make life as difficult as possible for immigrants trying to navigate an already complex system. This is yet another reason why we need Congress to step in and provide relief. There is a push for Congress to include the automatic extension of DACA TPS work authorization in the next COVID-19 relief bills. So that's the current ask that we're pushing for, given, again, the abrupt change to the DACA program, the inability of people to be able to get legal services right now due to COVID-19, requiring many of these offices to be closed. And of course, the economic situation of our country. So we're really pushing for that. We hope Congress will take that into consideration and make the changes that are necessary to keep people's lives as stable as possible under these unprecedented times. Some members of Congress may hesitate because they don't see much of an urgency around this ask, particularly because people who have DACA can continue renewing it every year, right? But it's still important to make this change because, as I mentioned, now these individuals have to pay every year $495 to continue having protection from deportation and their work authorization rather than every 2 years. So we continue making the ask, not just for those who have DACA, but also for those who are under TPS, who are also able to continue having TPS for select countries only because of courts' interference.